Welcome to Jobline, Long Island's only program devoted to career opportunities and workplace issues. I'm Scott Possessor. With the job market still dragging across the bottom of the seafloor, I continue to hear nightmarish stories of possible wrongful termination, age discrimination, sexual harassment, defamation of character, and even bullying in cyberspace and the workplace. But how do you really know if your employer has treated you inappropriately, indelicately, or illegally? While there's no easy answer, today marks the introduction of Sara Kane, a partner in the law firm of Valley, Kane, and Vagnini, to the Jobline family. Sara's firm represents individuals who have been wronged by companies, so you want to pay close attention to this segment. So you'll know what to do if you think your company has treated you unfairly. Sara, welcome to Jobline.
Thank you.
Good morning. Your maiden voyage.
Thank you.
We have so much to talk about. We had a great pre-interview a week ago, and we talked for about an hour, it seemed.
Yeah.
And it was so much ground to cover. But the first thing I want to talk about is so many people on Long Island don't have a job. They don't know if they're being discriminated against because of age. They don't know if it's just because they don't have the right experience. They don't know if it's because of gender or because of nationality. I mean, there's so many things that come up. But then there's also the people that have lost their jobs that are very angry, and they don't know if they were wrongfully terminated or give us a little bit on wrongful termination. What is the definition of what is a wrongful termination?
Well, unfortunately, most people are at-will employees, which means that unless they have a contract, which most people do not, they can be fired or quit at any time for any reason, unless it's a discriminatory reason. And that would be where the unlawful aspect comes in. So, for example, if you are treated differently because of your race, your age, your religion, your gender, your national origin, disability, if one of those is a factor in why you're terminated, then you might have a legal claim that might be illegal. However, if you're fired because the person doesn't like you, and it has nothing to do with one of those factors, or you wore a purple shirt and they thought it was ugly. I mean, I'm being ridiculous, but the point is that you can be fired for any reason or no reason at all, unless it's a discriminatory reason. And what I tell people a lot is unfair doesn't equal illegal. And there might be very unfair circumstances that are that are upsetting and difficult to deal with in a termination situation or even in a workplace situation, but it doesn't mean it's illegal. It doesn't mean you have a legal claim.
You've been with a company 20, 25 years, and now you're 59 years old, and suddenly for performance issues, which you don't really believe, they're letting you go. Is that something that people should really be?
You know, that's a tough one, and the law has changed recently about this when you're dealing with age. The Supreme Court came down last year with a ruling that said if you're going to claim that you have an age issue, you better be able to prove that it's only because of your age that this happened. But for your age, you would not have been fired. So unless you're able to show that, and that was the reason that you got fired, you're going to have a really big issue. And that's hard. I mean, it's very rare for someone to come up to you and say, hey, you're 59 and I don't like you because you're old, so I'm firing you. I mean, that doesn't happen. You know, it's very rare. If it happens, then, you know, certainly call me. But that's not the situation that most people find themselves in. They have more of a situation like you just described where there's the claim of some other reason. And if there's a legitimate business reason that they're going to offer and you can't counter it with evidence that you've been discriminated against based on your age, you're going to have a tough claim with an age claim. That's not the same for the other areas that we discussed, but that's age. However, if you have a class issue, if you have 30, 40 people who've been fired or laid off that are all in the over 40 category, and you have a class-wide claim, that's different. The Supreme Court did not touch on that issue when they made their ruling. So, you know, for example, I have a case against post office, actually, where I have upwards of 40 people complaining that they've been discriminated against based on their age. I have a similar situation against the Nassau County Police Department, actually. Also age, and it's class, it's a different issue. It's not as limiting as an individual person's claim.
Let's switch over to severance packages. Okay, it's bad enough that you're losing your job.
Right.
Does the company have any responsibility with severance beyond their own internal policy?
No, they really don't. There's absolutely no obligation under the law to provide a severance package to anyone. And that, again, would bring you back to, are you being treated differently than other people? That would be the only area you could possibly have a claim if, you know, all of the white people getting terminated are getting severance packages, or laid off are getting severance packages, yet all the African Americans are not. Obviously, that's a disparity. That's a possible legal claim because there's a difference in the treatment. It's always about comparisons in this area. So other than that situation, no.
Okay, now let's say that you do think you've been unfairly let go for age discrimination or for any other reason, and you now want to make a complaint. You know, do you take this to the Equal Employment Opportunity Commission? Who do you take that complaint to?
I mean, it depends on the scenarios, sure. You know, if it's a situation where you've already been let go and there's nothing to do with the company anymore, there's the Equal Employment Opportunity Commissions, there's the New York State Division of Human Rights, there's areas, there's, you know, calling an attorney. There's a number of avenues that you can explore. If you're still employed and you feel like you're having an issue at the company, my first piece of advice is complain. Make a written complaint, an email, a letter, certified mail, somewhere you can say, I sent a written complaint to Human Resources, to my manager, about the fact that I feel like I'm being treated differently than another employee based on my protected class, based on my age, based on my race, my religion, my gender. If you don't complain, a company can't be held responsible, because how can they be held responsible for something they don't know about?
And there's no documentation.
Right.
We have to take a break.
Okay.
This conversation will continue when Jobline returns. Stick around. Welcome back to Jobline at News 12 Long Island. We're continuing our discussion on knowing what your rights are in the workplace. Joining me once again is Sara Kane, a partner in the law firm of Valley, Kane & Bagnini. Sara's firm represents individuals who feel they've been wronged by their company. Sara, we could go on and on with this, but I do want to get on to sexual harassment. This is a question from a viewer. Is it sexual harassment if somebody at the company that you work for is having a relationship with somebody else at the company that you work for, and this impacts your ability to get a promotion or special projects or whatever, because they seem to be getting all that work? Is that considered harassment?
It's an interesting question. I mean, there are a lot of ways for someone to be sexually harassed, and it's certainly, if your terms and conditions of employment are being altered because of someone else's relationship that's in the workplace, that certainly could potentially be a claim that could be a problem for you. But you know, someone being sexually harassed, if it's a consensual relationship, for those people, that would not necessarily be a claim. There's a lot of factors. It's hard to answer that really actually on the fly. It's a long, involved answer, but basically, every situation is different, and you'd have to really explore the details of each one.
Okay.
Yeah.
And what about profanity in the workplace? If you're a person that doesn't want to hear profanity, and all of a sudden people are using profanity and liberally using profanity, you know, do you have any recourse with that?
No. Unfortunately, people are allowed to be unprofessional. People are allowed to manage poorly. People are allowed to create an environment that's really not that pleasant, but unless it falls into one of the categories we discussed earlier, and it's actually discriminatory or harassing in a sexual nature, then you're not really going to have much there, unfortunately.
I want to talk about online, because with Facebook and the popularity, my God, the immense popularity of things like Facebook and now LinkedIn and so many other things, I think defamation and cyberbullying become part of the workplace, you know, very unpleasantly so. What are there any tips, rules you can give us about that?
You know, this is a newly evolving area of the law, clearly, because all of this is so quickly changing. And people ask me all the time, are people allowed to look at my Facebook page, and can I get fired for what's on there? And I always tell people, just be smart. You know, there's no correct legal answer at this point, because it's so new. But be smart about what you do. And if you don't want people to potentially see something on that Facebook page, then you make it private so nobody could see it other than the people you expect to be looking at it. Just be smart. Be smart about what you do, and don't have an anticipation of privacy in the workplace that you should not have.
If you work at a company, can a company listen in on your phone conversations or look at your email legally?
Yes, that's what I was saying. Don't have any expectation of privacy. You look at your own Yahoo account, but you're on their computer, they can look at it.
Right.
They have the right to know what's going on in their workplace, and it's to monitor people.
Right.
Most handbooks have it in there. We have the right to do this.
Right.
And I would be careful. There should be no reason for you to expect that you have privacy if it's in someone else's place.
What if someone says something wrong about you because they hate you? So they say they go online and they go to some complaint bureau or something, and they say, you know, this person is a rotten person, cheats, lies, and steals, whatever. What can you do about that?
Well, defamation is a very specific thing. You have to have a statement that is made that is untruthful, that a third party, that is said to a third party, that the third party actually believes. So there's a couple of factors there that would have to fall into place in order for there to be an actual legal claim. You know, if they're saying something that's true, you know, that's not a defamation claim. That's not a problem. If they're saying something only to you one-on-one, that's also not defamation. And if they're saying it and the person's like, I don't believe that about them, that's not a belief by a third party.
But if the claim is false and you can prove that it's false, but it's already on the web, how do you get it down?
Very tough. Very tough. This internet is a tough thing. When something's out there, it's very hard to get it off. Very difficult.
All right, we're gonna give some information. If you'd like more information on Sara's firm, the address is www.vkvlawyers.com. You can also find that info on news12.com under numbers and links. Up next, mastering the art of networking, the innovative steps you can take to get out there and raise your profile when Jobline and News 12 Long Island returns.